Major breaking news. I'm shooting this on the side of the road. In the case in federal district court in Kansas, in the case of United States versus Morgan, a federal district court judge has just said that machine guns, you heard that right, automatically firing machine guns are protected arms under the Second Amendment, and thus an indictment under 18 U.S.C. 922-0, which is the so-called Hughes Amendment, is unconstitutional as applied to Mr. Morgan. Now, the judge that decided this is John Brooms. He's a Trump appointee, by the way. The District Court of Kansas is within what's known as the 10th Circuit Court of Appeals. They're okay on guns. They're not perfect, but they're okay. The analysis of this, I'm going to tell you about the analysis of this judge, and then I'm going to talk to you about what's going to happen next. The analysis was not terrible at the textual level. It's clearly correct to say that machine guns are arms under the definition of the right of the people to keep and bear arms. Machine guns are clearly bearable arms. There's no dispute at a textual level. That's true. So the burden then shifts to the government. Judge Brooms points this out. And what is the burden on the part of the government? Well, this is where he got it slightly wrong, not terribly wrong, but slightly wrong. He failed to recognize that the binding precedent was Heller that says that firearms or arms that are dangerous and unusual could be banned. He tried to draw a distinction between carrying dangerous and unusual weapons versus possessing dangerous and unusual weapons, but Heller doesn't draw that distinction. It basically says that government can ban the possession of dangerous and unusual weapons, and went on in the Heller case, of course, to say that because handguns are not dangerous or unusual, they cannot be banned because they're not unusual. Now, in this case, this is a key fact that the government screwed up, and this is why I think ultimately this case will be appealed and reversed by the 10th Circuit with an asterisk I'll get to in 1 second. The data that the government used to argue, or just that the defendant introduced this, was that there are over 760,000 machine guns in the United States under the NFA lists, and therefore they're in common use. But that is actually not accurate when it comes to comparing apples and apples and oranges with oranges. Specifically, the Heller case said that when you're measuring in common use, you have to look to law-abiding American citizens. And that 760,000 NFA item figure as to number of machine guns includes not just the approximately 170,000 machine guns held by American citizens on the NFA list. It also includes machine guns held in the possession of law enforcement agencies such as state police and local police departments. That does not count because they're not law-abiding American citizens, they're police agencies. So the correct number for in common use is about 170,000. Arguably that is below the 200,000 number in the stun gun case of Caetano in 2016, at least the concurrences by Justice Alito. So again, I think this will be appealed, and one of two things are going to happen. Either the 10th Circuit Court of Appeals will likely reverse this, and then I think the Supreme Court would deny cert on that, or alternatively, if President Trump becomes the president, then I think there's a good chance that the Department of Justice under President Trump would simply drop the appeal and let this dismissal stand. That's possibly the case to avoid any sort of crazy precedents, because the reality is, folks, even though I'm pro-machine gun, I got no problems with people owning machine guns. The reality is, in my professional assessment, that I do not think we have, on the current Supreme Court of the United States, 5 votes to protect machine guns as under the Second Amendment. I just don't think we have the 5 votes. I'd like to be wrong on that point. I just don't think I am. So anyway, very big decision. U.S. versus Morgan. Machine guns are protected arms under the Second Amendment. Indictment dismissed. I don't think this is going to stand the test of time, at least in the short run, or at least over the next couple years. But nevertheless, we will certainly watch this as the appeal progresses. And what happens if Donald Trump is elected and takes over the Department of Justice? Anything could happen. But with that said, I'm just bringing you the breaking news. Exciting news out of the District of Kansas. And we'll be getting back to our studio soon enough to do more videos very soon. And we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.